Hi, I'm Dylan Roberts. I'm an attorney with Gould Cooksey Fennell, and I work with our estate planning and our tax group. I'd like to answer a question that clients frequently ask, either planning to move to Florida or after they've moved here. So it's not uncommon for a client to ask us, how do I make Florida my permanent place of residence? How do I establish Florida residency? So to answer that question, I can easily say that once a client or a person moves to Florida with the intent to make Florida their permanent home, they've established Florida as a domicile, and that's an intent-based question. Florida takes the position that if you've established your domicile here in Florida, then you're a Florida resident. Now, what's confusing and frustrating oftentimes to clients is to learn that their home state or state where they've moved from still takes the position that they're a resident of that state, notwithstanding the fact that they've moved here to Florida. Now, it's kind of important to understand that residency on a state-by-state basis is generally a statute-created concept. It's a legal concept. There are tests that are objective that establish whether or not a person is a resident of that state. So the state that you're moving from, it could have certain days of the year tests or other nexus that establish that you are a resident, notwithstanding the fact that you've moved to Florida, established Florida as your domicile, and made Florida your permanent place of abode. So one of the ways that we've been successful in getting residency, that nexus of residency severed from other states, is working with advisors or former advisors of our clients as they're moving out of those states. There are certain checklists, there are certain things that we can do to establish a clear and defined date when that client no longer meets those statutory requirements for residency of their former jurisdiction.